Hi, my name is WIMONSIRIKNA, anak perempuan Wishan, and my metric number is 280877. I am the moderator for this forum. We are going to discuss the case study about security in banking. There are many types of security which are land or landed property, assignment, debenture, guarantee, indemnity, plate of goods, stock and share, bill of sale, and others. Based on this case study, a guarantee is a written agreement that obligates you to cover the borrower debts in the event that they are not paid. When the borrower defaults on your obligation to pay, the financial institution may bring legal action against the guarantee. According to the Section 79 of the Contract Act 1950, a contract of a guarantee is a contract to perform the promise or the discharge the liability of a third person in case of his or her default. As long as they can fulfill the legal condition, anyone can serve as a guarantor. Guarantee have two types, which is corporate guarantee and personal guarantee. In this case, Ibu Kota Ductile Iron Pipe Industries NAFAHATUS is the borrower, and the guarantor are Ibu Kota Realties NAFAHATUS as defendant 1 and Loh Jia Hong is defendant 2. Corporate guarantee is essential to corporate operation, particularly when obtaining or generating finance. And personal guarantee is an agreement between three parties, which are the lender, borrower, and the guarantor. The question that I want to ask to the speaker number 1 is, what were the issues raised by the defendants?
Thank you to the moderator, which is Ms. Rikna. My name is NURUL EZZATY AYUNY, binti AHMAD KAMIL, matrix number 281193. I will be the first speaker. I will answer to the question, which is, what are the issues that has been raised by defendants? In their respective objection declaration dated on 7 June 2022, which has been stated at Appendix 11 and 12, neither defendant dispute their responsibility as guarantors. They only recontest who is plaintiff reported quantity. There are 4 issues has been raised by defendants. The first issue is throughout the notice of demand dated 10 March 2017 to the borrower, and it needed the notice of termination dated on 16 May 2017 to the borrower. Plaintiff failed to explicate the principal method of computation and the ECOF, which also known as effective cost of fund rate. In his opinion, his argumentation is both unnecessary and counterproductive. The borrower received both the notice of demand dated on 10 March 2017 and the notice of termination dated on 16 May 2017, and not the defendants. Next, the second issue that has been pointed out by defendants is, according to the defendants, plaintiff failed to tell them of the modifications to the ECOF rate, which were made without their knowledge or approval. However, plaintiff had already notified the borrower via notice dated on 2nd September 2016 that plaintiff's base lending rate, base financing rate, will be 6.75% annually effective on 1st September 2016. This correspondent to the plaintiff ECOF rates. The ECOF rate sought in the current lawsuit against the defendant is 6.15% annually as opposed to 6.75% annually. So in the lawsuit against the borrower. Last but not least, the third and the fourth issue were the defendants contend that plaintiff should be held accountable for the other securities he owned and sold. Additionally, plaintiff has appointed a receiver and manager but hasn't completely sold off the securities that were owned. Plaintiff is so barred from bringing this lawsuit according to the defendants. Such 2 points will be taken into consideration collectively. Several issues were brought up in the defendant's separate opposition declaration dated on 7 June 2022 at enclosure 11 and 12. However, they were not mentioned in the defendant's written arguments. Counsel for the defendants acknowledged that they were dropping these claims at the hearing on 22nd July 2022. I will nevertheless address them to be true. In conclusion, none of the concerns brought up by the defendants may be tried in court. on the basis of the terms and conditions contained in the security papers and the other guarantee agreements, all of the arguments made by them have been refuted in plaintiff's behalf. There is no justification for this lawsuit to proceed to trial because no new information could come to light that will clarify how the security and guarantee contracts should be interpreted. The defendants do not contest their responsibility under the terms of their individual guarantee papers. That's all from me. Thank you.
For speaker number 2, the question is, does the plaintiff have the right to enforce the guarantee provided by the defendant due to the loan facility being in default?
Assalamualaikum and good day. I'm SITI NURFARAHAIN binti JASNI as the second speaker for today. Okay, back to the question from the moderator. Does the plaintiff have the right to enforce the guarantee provided by defendants due to loan facility being in default? In my opinion, yes, because the lending facility is in default, the plaintiff has the right to enforce the defendant's guarantee. A contract of guarantee according to Section 79 of the Contracts Act of 1950 is assigned to execute the agreement or terminate the obligation of a third person in the issue of his default. In simplified terms, an assurance is the guarantor's pledge to pay the creditor in the primary debtor fails to do so. It is preferable to have security from the person to whom the loan is issued, but this is not always achievable since the borrower may not have sufficient assets. Furthermore, a guarantor is only liable under a guarantee if the borrower fails to make payments to the financial institution and the financial institution makes a claim on the guarantor. In this case, we have demonstrated the principles, methods of calculation, and the ECOF effective cost of fund rate in the notice of demand dated 10 March 2017 to the borrower and the notice of termination dated 16 May 2017 to the borrower. Both were issued to the borrower and not to the defendant. There is no requirement under the law or under the security documentation for P to state in its notice of demand and notice of termination the principles, methods of calculation, and the ECOF rate as contained by the defendants. The principal sum, interest, late payment, interest, and charges have been quantified in both the notice of demand and notice of termination to the borrower. Lastly, the defendants have raised no tribal issues. All the issues brought by them have been addressed in favor of P based on the terms and circumstances of security documents and guaranteed agreements. Also, there is no need for this matter to go to trial since no new facts could emerge that would cast light on the security paperwork and guarantee papers under consideration. The defendants do not dispute their obligation under their various guaranteed agreements. They just deny the amount stated without proving it. However, the defendant's guarantees are new securities to P and are not affected by the establishment of other securities. And plaintiff is not required to exhaust all its rights under the other securities before enforcing the defendant's guarantees. As a result of the lending facility being in default, the plaintiff has the right to enforce the guarantee offered by the defendants. I think that's all from me. Thank you.
For speaker number 3, do the defendant have the right to contain the plaintiff when the plaintiff failed to inform the defendant on the charge of rape, which they claim that the changes were outside of their knowledge and consent? Can you give your opinion?
Assalamualaikum dan salam sejahtera. Thank you for the moderator. First, I will introduce myself. My name is NAFAHATUS SOFIA binti ABDUL RASHID and I am the speaker 3. Back to the question from the moderator is that the defendant have right to contain the plaintiff when the plaintiff failed to inform the defendants on the changes of the rate, which they claim that the changes were outside of their knowledge and the consent. In my opinion, both defendants, which are Ibu Kota Realty Sdn Bhd and Loh Chiat Hong, lack the legal standing to challenge the plaintiff, which is Bank Pembangunan Malaysia Berhad, on the reasons that they state plaintiff failed to inform them on the changes of rates. In my view, this is irrelevant for defendants to argue the plaintiff because the borrower's right to the information on loans which the financial institution is subject to borrower consent. Furthermore, in the notice of demand on 13 March 2017 and the notice of termination on 16 May 2017 that contain the principal sum, interest rate, late payment interest and charges were issued to the borrower, which is Ibu Kota Ductile Iron Pipe Industri Sdn Bhd, instead of the defendants. Moreover, on 2nd September 2016, the plaintiff has informed the borrower that the base lending rate, which is ECOF rate, effective on 1st September 2016 will be 6.75% per annum. After that, no more notice issued to the borrower on the changes of ECOF rate by the plaintiff. Besides that, under the security document, which are in first facility on 23rd May 2007, and the second facility on 15 December 2010 state that the plaintiff have right to vary the ECOF rate. It has been agreed by the borrower. So in this case, both defendants have no right to challenge the term and condition that have been agreed between the borrower and the plaintiff. So, for the result of this case, in my view, the defendants have no right to contend the plaintiff on the claim that the defendants are not informed on the rate changes. Okay, that's all from me. Thank you.
For the last question, speaker number 4, can you explain the type of guarantee for defendant 1 and defendant 2 and their liability as principal debtor?
Thank you to our moderator for the questions. Assalamualaikum and hello everyone. My name is Azfar Binti JESMEN. My matric number is 28009. As a speaker 4, we'll answer these questions. So there are two types of guarantees, which is corporate guarantees and personal guarantees. So I will continue with the first, defendants, which is Ibu Kota Realty Sdn Bhd, is categorized as a corporate guarantee, which is an agreement between the company entity and the borrowers. So, the company acts as a guarantor for the Ibu Kota Ductile Iron Pipe Industri Sdn Bhd that pledged to assume a liability for the debtor's obligations, including debt repayments. So, when the firm guarantees repayments of the loans given to one of its subsidiaries, the individuals who signs the agreements should ensure that the loans will be repaid, even if the subsidiary defaults on the loan. So, as for the defendants 2, which is Loh Chiak Hong, is categorized under personal guarantees, which is an unsecured loan arrangements that empower lenders to take a guarantor's personal asset in the event of the loan failure by the connected borrower. So, it also an individual legal promise to repay the loan's default by the borrower with his personal assets. As you can see, based on this case, since the Bank Pembangunan Malaysia Berhad, who are creditors, have a legitimate to claim the person's assets, which enforcing personal guarantees will reduce their risk. As you can see, both types of guarantees have seems to be same in the terms of the purpose, but there are also a little differences between them, which is for the personal guarantor is a person who consents to consume the debtor's obligation, while the corporate guarantor is a firm that assume payment obligations. Okay, next, so I will continue with the liability as a principal debtors. In a guarantee, the guarantor is held responsible if the principal debtor fails to pay back the loans. So I will highly recommend that and encourage you to read and comprehend the guarantee's contract before the signings, because it will impact in the future. The level and the amounts of the liability of the guarantor will be shown on the guarantee documents. The guarantor will only be held responsible under the guarantee if the borrower fails to make any payments in any financial institutions, and that institutions will make the claims on the guarantor. Okay, so based on this case, any periodic adjustments to the ECOF rates will be binding on the defendants, even the defendants have been approved or aware to the changes. So both of the guarantee papers terms are explicit, and the defendants are obligated by them. So the defendants' guarantees constitute extra securities to the P and cannot be diminished by the issuance of other securities. So that's all from me as a speaker 4. I hope I will answer the questions given by the moderator. Thank you.